Case People versus Thomas Styron. Here we go.
From the very first seconds, tension is already brewing in this courtroom. What should be a routine case call immediately begins showing signs of conflict. Thomas Styron is facing criminal charges, and instead of moving smoothly into proceedings, the court must revisit a critical issue, whether he wants legal representation or intends to defend himself. Representing yourself in court is legally allowed, but it's incredibly risky. Judges must ensure a defendant understands the consequences because courtrooms operate on strict procedural rules, evidence standards, and legal technicalities most people simply don't know. What makes this case gripping right away is the emotional energy. The defendant appears frustrated, possibly feeling misunderstood, while Judge Simpson is focused on keeping the courtroom orderly and efficient. And this raises our first big engagement question for viewers. If you were facing serious criminal charges, would you trust yourself to represent your own case? Or would you rely on a professional attorney? Because from here on, every decision Styron makes directly impacts his future.
Assistant Public Defender Ortella on behalf of Mr. Styron, who stands to my left. Well, let's talk to the judge about that. Right?
We've been through this. Seems to be some confusion.
What's the confusion?
I've stated multiple times on the record that I wish to represent myself.
Well, I thought we got rid of that issue the last.
Yeah, I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
All right. Well, if he doesn't want you, I mean, we'll figure that out in a moment. So, Mr. Styron, we're going to go through this again. What do we want to do in this case? You understand what you charged with, sir?
So, I understand what the charges are against me, yeah.
Okay, look, you're going to have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here.
From my understanding,
You understand, first of all, that if you do indeed direct, you want to smile about it and laugh about it, take him back. We'll call him out later. Take him back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up.
This moment marks a turning point in courtroom tone. Contempt of court isn't symbolic. It's immediate jail time used by judges to maintain authority and order. When the judge warns Styron about laughing, he is signaling that courtroom behavior is crossing into disruption. Courtrooms demand seriousness because decisions affect liberty, reputation, and public safety. When someone appears to mock proceedings, judges often act quickly to regain control. From Styron's perspective, he may feel frustrated or unheard. But judges interpret behavior through the lens of courtroom order, not personal emotion. The escalation happens quickly, showing how fragile courtroom dynamics can be. Here's the engagement question. Do you think the judge acted too harshly, or was strong action necessary to keep order in court? Because now, and before trial even begins, Styron is already serving time for contempt, something that can shape how future hearings unfold.
You may need an attorney. Your fault. Court calls the case of the people versus Styron. Recall.
You're compelling me to identify as Thomas York Styron, the legal entity on this case.
I believe that you are. Do you understand the nature of the charge, sir?
I don't understand how the name you have on the case and who I am is two different people.
Defendant, as he was leaving the courtroom the last time, the court did find the defendant in contempt, sentenced him to 30 days. The defendant will serve that sentence. The court will sign the judgment of sentence regarding the contempt.
I don't understand how that's possible. Like I said,
So first of all, watch your language.
You're treating me as if I'm the trustee or...
The confusion deepens as Styron challenges how he is being identified legally. Courts operate strictly under legal identity, your official name, records, and charges. When defendants argue identity distinctions or legal entity theories, proceedings stall. Judges must keep discussions grounded in law, not philosophical arguments about identity or government legitimacy. Courts across the country consistently reject these types of arguments. From Styron's perspective, he feels misrepresented. From the judge's standpoint, the court must proceed using recognized legal frameworks. Emotionally, both sides grow frustrated, and once frustration builds, cooperation becomes harder. Engagement question for viewers. If someone believes the legal system misunderstands them, should they fight the system directly or work within it to defend themselves? Because at this point, Styron begins his legal journey already under tension with the court.
I don't want to partake in any trust fraud or anything like that. Is this a Sesquive trust matter involved in this? Is my social security number attached to this at all? Go figure.
Mr. Styron, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up. You will learn how to conduct yourself appropriately in these proceedings in this courtroom and before me. You will not in any manner whatsoever
You're trying to compel me to be somebody I'm not.
Or this institution.
You have no evidence
It will not
to prove
happen.
that I'm who you say I am.
You will not talk to me in that fashion.
In what fashion? I'm not the one being unethical.
Very good. You'll serve the 30 days. We'll see. You can go right there. We're having it. Court does call the case of People's State of Michigan versus Thomas Styron II.
Good afternoon, Your Honor. I'm Phil Hughes on behalf of the club.
Sir, state your name, please.
I'm George Styron II.
All right. This date time set for preliminary examination. Mr. Styron, you are here representing yourself. I would indicate to you that there are 3 charges on the complaint in this case. The first charge is that of fleeing a police officer under the Motor Vehicle Code in the 3rd degree. That is a felony punishable by up to 5 years and a $1,000 fine plus court costs. Count 2 on the complaint alleges assaulting, resisting, and obstructing a police officer. That is a felony punishable or a high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court costs. Count 3 is a charge of driving while license suspended, denied, and or revoked. That is a misdemeanor.
Now the real stakes emerge. Styron is facing multiple charges, including felonies. Felony charges can lead to prison time, not just fines. This is why Judge Simpson repeatedly ensures Styron understands his right to counsel. Representing yourself means mastering evidence rules, legal arguments, and procedure, tasks even trained attorneys struggle with. The judge carefully outlines rights and consequences, ensuring any waiver of counsel is informed. But confidence often hides how complex court proceedings truly are. Here's the viewer engagement moment. Should courts require legal representation in serious felony cases, or should defendants always have the freedom to go it alone? Because from here forward, mistakes carry heavy consequences.
Punishable by up to 93 days in jail and or a $500 fine plus court costs. The subject matter of this preliminary examination is for the people to establish by probable cause that the felonies have been committed. If the people do establish that, then you would be what's called bound over to stand trial in the circuit court. You are here appearing without counsel. I would advise you that if you wish to represent or be represented by counsel, you can let the court know, and the court would make sure that counsel would be available to you in this proceeding. I would also indicate that if you are desirous of continuing to represent yourself, you certainly have an absolute and constitutional right to do so. You will be held to the same standard that attorneys are held to regarding the court rules, regarding the presentation of evidence, and anything else along those lines, as well as questioning of the witnesses. Do you understand all of that, sir?
I understand everything.
Pardon?
I understand everything.
Okay. And, sir, do you still wish to proceed unrepresented? Very good. Do you have any questions before we begin the preliminary examination?
I haven't had a chance to look at the body cam and the evidence. I just got a kite back yesterday telling me I could ask the noon staff to be able to view this. I've got maybe 45 minutes or an hour's worth of time in it so far, able to get through the first day.
45 minutes, an hour into what?
I think there's 16 videos on the thumb drive, and I think Officer Hooks is an hour and 15 minutes long in itself. So what I'm saying is I've had insufficient time and evidence to even review it, to be able to articulate.
Excuse.
Your Honor, I understand that the APA that was present before me had intended to admit that some of the body camera. I will not be using any of it today. I'll be proceeding with just Sergeant Houk's testimony.
I guess and I understand that misuse, and I guess the only question would be if whether or not something contained on the body cam might lead to evidence that the defendant either would want to present or lead to evidence that the defendant may wish to question the deputy on. And I'm going to have no way of knowing that.
I appreciate that, Your Honor, especially because my office previously put on the record, and I'll reiterate today, we do plan on adding additional charges, account of felonious assault, which assault with a dangerous weapon against the sergeant, and 2 counts of felony firearm.
This is a major escalation. Prosecutors announced potential additional charges involving weapons, which dramatically increases legal risk. Weapon-related allegations raise public safety concerns and influence bond decisions. Prosecutors argued detention protects the community. Styron now faces a much more serious legal situation than initially presented. New charges can drastically change defense strategy. Engagement question. If you suddenly learned your case might include even more serious charges, would you still represent yourself or immediately ask for legal counsel? Because this moment raises the stakes significantly moving forward.
Which are mandatory 2 years in prison. So, Your Honor, I don't have a problem if we need to adjourn this room to have more time with the video.
Okay. And under those circumstances, and I forgot, I think you had mentioned that before, that with that. Okay. So, Mr. Styron, you're requesting an adjournment of the proceedings so you can get through that. Is that okay? How far, and I guess I was unclear, you have access to the body cam?
Yes, I do. It's in my property.
Okay. But then you were talking about you got through some of it?
The first video, and I believe it's a not YouTube, but a Facebook video of a bystander.
Say that again.
A Facebook video that somebody took.
Okay.
And part of his body, maybe 20 minutes, half hour's worth.
When you're saying his, you're talking about
Officer Hooks, yes.
Okay.
I believe his body cam footage is an hour and 15 minutes in its totality. So I've barely been able to scratch the surface of that.
Okay, let me ask you. Go ahead. Were you going to say something else on that?
And like I said, I believe there's 15 or 16 videos in there total. Maybe more, and that's just what I was able to see.
Okay, so let me ask you this. How are you arranging to view that video?
So originally I was kiting everybody I could. I was correctional services, the sergeant, that sergeant. Finally, while down in correctional services, I was able to speak with Sergeant Flint.
Okay.
And he was able to arrange this first meeting. And like I said, I got a kite back from him yesterday telling me just to bother the noon staff and they'll arrange it during the noon shift. So
Gotcha.
Prior to yesterday, I was still asking. I guess I was just asking the wrong shift. I was asking later in the day, that's for certain. And I really was never able to get anything else arranged as far as being able to go and view it.
Okay, so you were trying to do it one way, that wasn't happening. You finally got to Flint, and he indicated to you that it's the noon staff you're supposed to bother to try to. Okay.
Flint's definitely provided direction in regards to how I can go about getting this.
All right. Okay. So
here we see a real challenge of self-representation while incarcerated. Styron says he hasn't had enough time to review evidence due to jail limitations. Evidence review is critical for defense preparation, but jail conditions make preparation extremely difficult. Limited staff, lockdowns, and restricted access slow everything down. Judge Simpson responds reasonably, allowing adjournment so Styron can review materials. Engagement question: do jail defendants truly have a fair chance to defend themselves, or does incarceration put them at a disadvantage? Because preparation time directly impacts courtroom outcomes.
We'll need to then adjourn that. Have you, well, I'm gonna ask it one or two ways. How long do you think it'd take you to get through it? I mean, is it your, and I won't hold you directly to it, but I mean, would you be able to do it in one day if you had access to it, or is it going to take you a few days, or just your best guesses? Because you know how long the clips are. I don't have any idea by design.
I only have knowledge of how long his particular video is, Officer Hoops. I don't, the other ones I haven't looked at, viewed, can't remember how big the file is, nothing like that. If I was out in the world, I could probably have this done within a week at my house. I have my own computer, and I planned on originally being able to do this. Also, it depends on the jail. They've been so short-staffed. We've been locked down a lot as well. So it depends on what their staffing numbers is during it. When I'm asking or trying to arrange this, there's so many variables. It'd be hard for me to give you a.
No, that's fair. That's fair.
And then also,
but you don't know total. You don't know total time how much there is. You just know that one.
Since May, I've been fighting an illness that just recently the jails addressed. So yeah, there's so many things going on. I've been since May. I've been having stomach issues, bowel issues, and on Friday or Saturday I was urinating blood. Finally, I was able to get some the medical staff to do something with that as far as me urinating a cup and give me some type of antibiotics. But all they can tell me is I have an infection. They just don't know specifically what type of infection. So I'm also dealing with that, and it's making me very lethargic. And
now the human side of the case appears. Styron discusses health struggles and delayed medical treatment. Courts must balance fairness with practical realities. Medical hardship alone usually doesn't justify release unless severe. But emotionally, imagine trying to prepare a defense while dealing with illness inside jail. Stress multiplies. Viewer engagement. Should serious medical concerns weigh more heavily when judges decide whether someone stays in jail before trial? Because legal battles are difficult enough without physical hardship added.
Okay, I got you.
energy in that.
What do we
That as well.
What do we look like on the 6th? Okay, so that we hopefully won't run into this again. You've gotten all of the discovery.
Pardon me.
You got all of the discovery.
far
Like
as
you got the, as far as you know, you got the police report. You have all of that. It's the video. All right. So what I will do is I will adjourn the preliminary examination in this matter. I would go to the 30th, but I think I'll go to August 6th. (2024) at 1. I'm going to set it at 1 p.m. We'll just push everything else out of the way, and that way we'll be here. So that'll give you 3 weeks to try to get through that. Now, if there are issues like what you're talking about, short staff, whatever, and you haven't been able to get through everything, talk to one of the deputies so that they can get in contact with my office, so that if we have to push it out another week, we can just get that done without you coming up here telling me you're not ready.
Fair enough.
Okay.
Got a question in regards to, is there any reason why that would be preferred instead of me being able to address what I got going on internally and at a hospital or outside in the world. I guess me being put on bond so I can take care of my illness as well as look at this discovery and handle that. So it'll probably be done in a more timely manner. There's less variables involved.
Your Honor, I'm not available before then anyway, so I'm very happy to come back in 3 weeks once he's had the opportunity to review it in the jail. And yes, as Your Honor is well aware, if this gentleman's ailments were to the level that he needed to be hospitalized, the hospitalize him. Additionally, the jail would notify their chain of command if there were any needs that exceed the jail's current ability to assist him. I've received no communication from the jail to that effect, which tells me it's not happening, meaning that the jail is the appropriate place for him. Also, Your Honor, I will, as the court knows, the defendant is in custody without bond for the defendant's demeanor in this courtroom. At the time that my office charged this case, we requested a $50,000 cash surety bond. This is a person who, while possessing a firearm, threatened to cook the sergeant, which is one of the reasons that I'm planning to go the information I had serious charges against him.
This moment shows prosecution strategy clearly. They argue Styron presents a danger, citing firearm possession and threats. Bond decisions weigh risk to the community, likelihood of court appearance, and safety concerns. Prosecutors argue detention is necessary. Styron counters, claiming he meant legal action, not violence, and that he actively pursued court proceedings. Engagement question: should judges prioritize public safety or personal freedom when facts are still being argued? Because this determines whether someone waits for trial in jail or outside.
Additionally, Your Honor, this case originally came in as a domestic violence call, and Sergeant Howe took the opportunity to try to protect the community by proceeding after this defendant in a manner to not only protect one individual woman, but to protect our community. And it resulted in this person possessing a firearm and not only threatening the sergeant, but threatening the sergeant's dog as well.
My rebuttal to that is, when I said cook, I made it very clear. I said it meant legally to the courts, which he iterated on his body cam. So according to the body cam video, he is fully aware that I meant legally through the court process. And also, I believe in the police report, he was sitting there for a welfare check with a possible rolling domestic, which led me being pulled over, me being a single person in my van, not two people, which would be involved in domestic, I imagine. And then once pulled over, pretty sure he knew I wasn't who he was looking for, just based on my appearance description, based on who was looking up in his talent or the lane system or whatever it is they use in the police cruiser. Make sure to iterate that I plan to use the legal system to address any transgressions or trespasses I felt was made against me. And sorry,
Go ahead.
Also, I was the one who stayed on top of these charges. I'm the one who called the court every day, stayed on top of this case, and I'm the one who arranged the court date with Ms. Fink. I was the one who called the courts week after week, and they didn't have my case in, and finally they did. I was very proactive in trying to get this addressed through the court system. Had no intention of running or trying to avoid it at all. And I think my actions were sued such.
In this matter, I'm not gonna at this point change your bond, Mr. Styron, and I'll just put it to you this way. I don't know the facts of the case. By design, I don't. So I'm going to certainly, I hear the allegations, I hear your response to the allegations, and at some point I'll see the evidence. In terms of what I had previously heard in regard to this case, I would consider your actions on that date, at least.
Judge Simpson explains he is not declaring guilt, but assessing risk. Courts must balance presumed innocence with safety concerns. Styron's earlier courtroom conduct now influences decisions. Behavior matters in judicial perception. Engagement question: should courtroom behavior influence bond decisions, or should only evidence matter? Because impressions inside courtrooms last longer than many realize.
As I understand them to be at this time, that you pose a significant risk to the public and to public safety by your conduct that day. Okay, I'm not sure about the comments. We'll deal with that. Further, as the prosecutor indicated, your demeanor in the courtroom prior to today leads the court to question whether or not releasing you, I could trust you to do what I ask you to do. This is the first time today, as we were talking to each other, going through the things, that it's been a civil conversation with you to try to resolve the things. All I'm trying to do is get the case through. I don't know why the other days you made a determination to try to act a particular way to the court, because I'm just, like I said, I'm just here trying to get the case heard and get everything done. And so I have, based upon what I hear regarding the case, what I also have seen in terms of your demeanor in the courtroom, I have great reluctance in terms of doing that. What I will tell you is this, is that I certainly will address, so I'm going to deny your request to the extent it was a request to change your bond in this case at this time. Certainly, hopefully we'll be able to go forth on the 6th.
Bond remains denied. Judge Simpson leaves possibility open for future reconsideration. Styron appears calmer now, and judges do recognize improved behavior. Cooperation often helps defendants more than confrontation. Engagement question. Do people deserve second chances in court after improving behavior, or should early mistakes stick? Because trust takes time to rebuild.
And I certainly will relook at everything on the 6th, and you could raise the issue again. But I want you to understand that part of it is because of what the allegations here are. And I'm not saying you're guilty of them. I'm not saying any of that. But in terms of the allegations and what could be and is, from this court's perspective, a situation where you may pose a risk to the community, but also a lot of it is of your own doing in terms of what happened here. Okay. And so all of that I have to take into and can take into consideration. But like I said, in fairness to you on the 6th, because today was 180 degrees from before. And so I will now factor that in. And on the 6th, certainly I will take a look at anything you just raised again before the court. Okay. And I would agree, just real quick, and I'll let you. I would agree with what Ms. Hughes has said, and that is that if your medical, or to an extent, our jail is excellent. I have to say the sheriff's office is extraordinary in making sure that people get the medical care that they need. But certainly you would have to apprise them of that, and I think maybe you have, and they will make sure that you're taken care of. I just don't have a doubt in my mind and have never had an issue with an inmate getting the care that they need. So, all right.
Two things. 4 times we've been adjourned because I asked to represent myself. I don't believe my demeanor played any roles in that. I thought it was because there was some misunderstanding as far as the courts and trying to represent myself.
Oh no.
And in regards to the medical thing, I reported this in May. It took until I got blood in July before anything was ever followed up on or done.
Okay. I suggest that you send another request regarding the medical issue. And Mr. Styron, I would also suggest to you, it never is an issue. I've had 2 others come through representing themselves. That is never an issue with me, because you have a right to do that. And I'm just going to let you know, that is not the reason. You need to go back and you need to look at what you were doing in this courtroom toward this court for reasons I don't even, Mr. Styron, understand. So I'm not here to debate that with you. I'm just telling you that's where it was.
What I was saying was, maybe I was misunderstood. That when we went to proceed with the court proceedings,
Styron argues confusion caused delays. Judge says behavior also contributed. Court narratives matter. Judges rely on memory and records. Engagement question. If misunderstandings cause delays, who should bear responsibility? Court or defendant? Because procedural confusion often leads to bigger consequences.
There was some misunderstanding in regards to the public defender's office representing me versus me representing myself. And since there was that misunderstanding, it was adjourned, I believe, four times over those matters. It wasn't because I was acted out or anything. I believe I came and went so fast. It wasn't even opportunities.
No, there were a couple of adjournments because of that.
Okay.
But that was because you needed, there was assistance you needed in regard to what we were dealing with at a particular given moment. And so that's where the PD was standing in. But no, it was your behavior on the date that I revoked your bond. And then the other dates were trying to make sure of that. And I was, I'll just be honest with you, Mr. Tyrant, I wanted to make sure that you truly wanted to represent yourself and that your rights were protected with having the PD here. And until I was clear on that, I wasn't going to let things proceed because, well, I'll just put it to you bluntly, you got a hot head sometimes. And I wanted to make sure you weren't making that decision just because and not fully understanding what this was, because these are serious charges and there potentially more that are coming. That's my whole thing on that. Okay.
I appreciate it.
All right.
One last question, if we're about to be done. In order to get a hold of your office.
Logistics matter. Styron struggles even to obtain envelopes to contact court. Judge Simpson works to ensure communication channels exist, even lightening the mood briefly. Engagement question. Should courts provide logistical support for self-represented defendants, or is that solely their responsibility? Because communication barriers can derail cases.
I can use the channel of the jail, not the mail system, because I don't have envelopes to pass information or anything that the jail is my channel that I go through to contact you and inform you of certain things, be it whether it's documents or
I'm not, well,
or in regards to me needing more time.
I think you would have to send some type of communication, written communication to my office. I don't think there's a direct line, and I'm not even sure how that works because I usually don't have inmates contacting my chambers directly. Sometimes they will mail things, which seems to me to not be it. Do you? Oh, there he is. So he'll figure that out. He'll let you know how to get a communication up to my office.
Right.
Okay.
Yeah.
And not whether or not I can do anything about it, I don't know. So when that happens, so that you understand this, Darren, whatever you send to me that I'm going to review needs to also go to the other side. But what I will do to try to make things easier, if this is okay with the people, is that once it comes to me, I will make sure that whatever you're sending to me, they're going to get a copy.
That works, thank you.
All right. Envelopes are $1 and I have no money in my account, so it'd be very burdensome to try and buy envelopes to send to everybody.
They're $1? Seriously?
Tough down there.
I got about $500 in back. That. Okay.
So
Why? No, I'm just saying, if I can sell it for $1, I'll just take the whole box down. Anyway, okay. So we sorted that out. Make sure to get with them. They'll make sure it gets up to us.
perfect. Thank you.
Okay,
Yeah.
Mr. Syra, I appreciate you behaving yourself this way. Because just listen, because you're coming in hot like you did before, I'm just going to let you know, with me or any other judge, that's a battle you're going to lose every time.
I can appreciate that. And
Tone shifts positively. Judge acknowledges improved behavior and advises cooperation. Courtroom dynamics evolve. Respect produces better results than confrontation. Engagement question. Do personality differences between judges influence fairness, Or should outcomes stay consistent regardless? Because temperament shapes courtroom experiences.
My only response to that is I've never had that happen. All the other judges I've ever had on front of, whether check Miss Fink, Miss Fink that was able to have a conversation after the court time.
She's nicer than I am.
She's a very nice woman, that's for sure. And
She's much nicer than I am.
like I
And
say,
so
they-
she has patience. Sometimes I don't.
fair enough.
So
This hearing closes with Styron still in custody, facing serious felony charges and potential new counts involving firearms. Judge Simpson maintains detention but allows preparation time. Styron continues representing himself, though risks remain high. Lesson: preparation, strategy, and courtroom conduct matter deeply. And now we ask viewers, who handled this hearing best? The judge, prosecution, or defendant? If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.